Good evening. Thank you for joining us. I'm Dr. Sarah Abosh Jacobson, the Barbara Rabin Chief Education Officer at the Dallas Holocaust and Human Rights Museum, and it is my great pleasure to welcome you all to the third installment of our annual Rule of Law series. I'd like to start by extending a special thank you to our sponsors for this program. Our founding sponsor is the Jones Day Foundation. We are grateful for their partnership, and we are grateful for their incredible generosity in helping to make this series a reality. Our presenting sponsor is the Sumners Foundation. Thank you for your ongoing support of this series. We are delighted to have in the audience tonight several Sumner scholars who are studying at universities across Texas and in Oklahoma. And tonight's program sponsor is Oryx USA, courtesy of David and Tina Nishida. Support from incredible sponsors such as these make our work possible. I would also like to thank our community partners for this program, Green Hill School, League of Women Voters of Dallas, the Legacy Senior Communities, and Southwest Jewish Congress. I am pleased also to extend a special welcome to our board members, museum members, generations, and volunteers with us tonight. Your contributions help us continue to offer programs like these. If you are not yet a member, and I'm looking at all of you who are not yet members, or a volunteer, please visit our website at dhhrm.org to learn more and hopefully to join us. I would now like to welcome to the stage Peter Lawn of Jones Day to give remarks, followed by a brief highlight video about the work of the Sumners Foundation to encourage lifelong civic engagement. Peter.
Thank you. Hi, everybody. Thank you, Sarah. We're grateful to be here this evening and even more grateful to serve as a founding sponsor for this incredible Rule of Law series. I'm Pete Lawn. I'm privileged to have spent 33 years of my legal career at Jones Day. We're a law firm with offices all over the world, 2,500 lawyers and 40 offices, I think. I pay taxes in most of them. The mission of the museum is important in many different ways. I think everyone's here for a reason. On a personal level, it honors the legacy of my Jewish grandparents and mother, who survived the Holocaust by leaving Germany in the middle of the night in 1939 after leaving their business and all of their personal possessions behind. They made their way across, in a company truck. They made their way across Germany into Holland and eventually into London, where my mother and her mother spent the war. It often occurs to me, I was telling Jessica earlier, it often occurs to me how unlikely it is that I'm actually on this earth, given that history. The failure of the rule of law in Nazi Germany came very close to preventing that from happening. On a broader level, with the rise of anti-Semitism and hatred crimes motivated by bias and other things all over the world, and frankly, a seeming trend toward curtailing critical rights, such as the freedom of the press, academic freedom, we're reminded why the rule of law is critical and why it remains important to learn from history, because as the adage goes, those who don't study history are doomed to repeat it. Jones Day is very proud, and I'm personally very proud, to partner with the museum on this important series, which examines the historical relationship and interrelationship between the legal system and human rights. The series aligns with my firm's values and with my personal values, as well as our efforts to promote the rule of law around the world. Among other things, Jones Day sponsors a series in Africa where we train judges and prosecutors to better be able to apply the rule of law in Africa. We sponsor an initiative with clients, including American Airlines, on anti-human trafficking initiatives, trying to prevent human trafficking and teaching people how to detect it. And we spent, I think it's $100 million or more in Laredo, Texas, handling asylum cases. The rule of law is fundamental. Thank you. We have a facility down there. Anyone who wants to join us down there and hear asylum cases, everyone's always welcome. We take clients, we take non-lawyers, we take everybody. It's a critical thing that we do. The rule of law, as everyone here knows, is fundamental to safeguarding individual freedoms, but also to ensure happiness and commercial stability in life. When the rule of law prevails, people can live their best lives and live the lives the way they want to. When it doesn't prevail, we see what happens. Jones Day is committed to supporting the museum's program to inspire positive change through education, and this program is one of many wonderful things the museum does in that regard. We look forward to today's program. I personally can't wait to learn more about this unfortunate moment in American history, but we look forward to this program, which enjoys wonderful speakers that teach us about what happens when the rule of law doesn't apply or is ignored, and what happens to societies when rule of law is not the guiding principle. So I look forward, like everyone else here, to listening and learning. Thank you.
We come from different walks of life and follow different paths, pursue different professions, practice different traditions. We are different. Yet one thing unites us. We are Americans. We are the Sumner's Foundation, developing a network of thought leaders around the founding ideals of self-governance by funding scholarships and investing in programs that educate and engage Americans. The Sumner's Foundation, on the job since 1949.
Thank you again to our sponsors, Jones Day, the Sumner's Foundation, and Oryx USA. Before we get to the main conversation, I wanted to cover a couple of housekeeping items. If you haven't done so already, please silence your cell phones. You don't have to turn them off, but put them on to vibrate so that we may all listen without disruption. Also, we will leave time at the end of the program for questions. Please write your questions on the note card that you were provided on your way in this afternoon or this evening, and our staff will come around to collect the cards towards the end of the program. If you are tuning in virtually, please use the Q&A button at the bottom of your screen to submit your questions, and we will get to as many of those as we possibly can. I would now like to introduce tonight's speakers. Eric L. Muller is the Dan K. Moore Distinguished Professor in Jurisprudence and Ethics at the University of North Carolina at Chapel Hill School of Law. He is an internationally recognized expert on the removal and imprisonment of people of Japanese ancestry in the United States from 1942 to 1946, and has published 4 books on the subject, most recently, Lawyer, Jailer, Ally, Foe, Complicity and Conscience in America's World War II Concentration Camps. He holds a JD from Yale Law School. Our moderator for tonight is Dale Carpenter, the Judge William Hawley Atwell Chair of Constitutional Law, Altshuler Distinguished Teaching Professor, and Professor of Law at Southern Methodist University's Dedman School of Law. He is the author of the award-winning book, Flagrant Conduct, the story of Lawrence v. Texas, about the landmark U.S. Supreme Court case that invalidated America's sodomy laws. He holds a JD from the University of Chicago Law School. I would now like to turn things over to Dale and ask that you get the conversation started. Thank you.
Well, pick this up. Thank you very much to the museum and to the sponsors for hosting this and for giving me an opportunity to speak with a scholar that I've admired for quite some time, Eric Muller. And let's get straight to this book. I'm excited to hear.
Let's do that.
Okay. Can you describe for us briefly Executive Order 9066? Why was it issued? What did the president hope to accomplish? What was it a response to?
Sure. So Executive Order 9066 was the order that empowered the government to undertake the program that we call today Japanese American internment. In its terms, it was very neutrally worded, and it simply gave the commanding general on the West Coast the authority to declare military zones and to do within those zones to people what he wished in order to guarantee security. There's nothing, you won't find the word Japanese in Executive Order 9066. It is neutrally worded, but it was clear from its history that it was created in order to empower the general specifically to remove all people of Japanese ancestry from the West Coast, regardless of whether they were US citizens. 2/3 of the 125,000 people that ended up in these camps were US citizens. And that's one of the distinguishing features of this period of history. We're accustomed to the idea that during wartime, the government can take action against what are commonly called enemy aliens, that is to say, people who are citizens of the countries with which we are at war. That's been the case. That's been something government can do since the late 18th century. But what this did, which was so distinctive, was to skip over the line between non-citizen and citizen and to impose exclusion orders and ultimately detention simply on the basis of ancestry. That was the key. If there were more time, obviously this executive order has a long history that reaches all the way back into the 19th century. Some of you may be familiar with stories of anti-Asian discrimination, the Chinese Exclusion Act in 1882, the exclusion of further Japanese immigration in 1924. This was in many ways a kind of culmination of that virus, I guess, that had been in the American body politic. It also, and I'll stop here. I know that I can go on a bit. By the way, I just want to say what a pleasure it is, and I think I can speak for Dale here, to be speaking to a group of people that are not required to be here. I mean, I just thank you so much. The other thing I wanted to mention is that the Japanese immigrants along the West Coast had established themselves as enormously successful particularly in farming. And this was an object of great resentment among white farmers along the West Coast who resented the competition and who had strong economic motives to want to, frankly, to get the Japanese out of California and Washington and Oregon. So in a perverse way, Pearl Harbor was something of an economic dream fulfilled for them. They finally had this military rationale that they could point to for something that they had wanted to do and been trying to do for decades.
So we have in this country long-standing privilege of filing what are known as writs of habeas corpus, which is the privilege of a person to challenge the factual or legal basis for their detention by executive authorities. Was there a challenge to this right after the order was entered?
So there were several challenges to this. One of them was a habeas corpus action. The best known ones actually were not habeas corpus cases. They were criminal prosecutions of young Japanese American men who decided to resist the orders to report for exclusion. The most famous of those is a fellow named Fred Korematsu. Some of you may have heard of his case, Korematsu versus United States. Right after Executive Order 9066 was signed, virtually the next day, Congress passed legislation that made defiance of Executive Order 9066 a civilian crime, a federal crime. So when Fred Korematsu and Gordon Hirabayashi up in Seattle, Washington, decided that they were going to take a stand and resist, they were prosecuted in federal court for their resistance. So both of those cases presented questions about the constitutionality of what was being done to Japanese Americans, but they weren't habeas cases. In some ways, the case that we should remember the most, but that is completely forgotten, is a habeas corpus case. And it's especially interesting for its time because it was a habeas corpus case brought by a Japanese American woman, a woman named Mitsuye Endo, who was incarcerated at the Topaz camp in Utah, filed a petition for a writ of habeas corpus asking a court to step in and review the constitutionality and legality of her continued detention in one of these effectively prison camps. Her case also made it to the US Supreme Court, and the US Supreme Court granted or affirmed her habeas corpus. That is to say, the Supreme Court ruled in her favor that the continued detention of loyal Japanese Americans was a violation of, not so much a violation of their rights, but it was something that the government lacked the power to do to them. So yes, there was a habeas corpus case, which I think deserves to be better known than it actually is.
And what was the reaction of the American public to all of this detention and executive order?
Mostly a yawn, I would say. Again, remember, if you put yourself in the context of the time, first of all, it was a West Coast issue, right? So if you lived on the East Coast, like my grandparents and parents did, this was not your story. This was something that was happening far away and probably something you were barely aware of, if at all. In California and Washington and Oregon, this was a very popular thing because, well, I mentioned the economic rationale already, but, the Japanese military had just attacked the United States at Pearl Harbor, and people were frightened. They were terrified. There were rumors circulating about squadrons of Japanese bombers coming over Los Angeles, rumors about threatened full-on invasion of the coast. So in an atmosphere of fear and hysteria, Japanese Americans did not find many friends. There were a couple of groups, the Quakers, distinguished themselves by standing by Japanese Americans, but most of America either didn't know it was going on or really didn't have much of a problem with it.
So we were at war not just with Japan, but we were at war with Germany and with Italy as well. And it seems that most of the detainees, the people interned, were of Japanese descent. Rather, some were German and Italian, but most were of Japanese descent. And you mentioned 120,000 or more. And there was a history, a long history that I think you referred to of anti-Asian legislation in the United States, preventing people from voting or owning land or testifying against white people or immigrating and so forth. But let me ask you, were there any steps taken before the order, before the camps were created to allay these concerns and ensure that Japanese Americans were loyal?
That's a very important question, and it's also a question that has current relevance. Some of you, many of you, who have the courage to follow the news these days may have noticed that the administration has invoked an old statute called the Alien Enemies Act of 1798. That's the statute that I actually referenced before. It's an old principle that when the United States is in a declared war with another country, resident aliens come within the scope of the executive power to control. And that's exactly what happened right after Pearl Harbor. The Alien Enemies Act was invoked. The FBI and military intelligence swept through communities along the West Coast and the East Coast, and as to people that they had some reason to suspect might be posing some danger, they arrested those people. And that was a couple of thousand Japanese aliens, some 8,000 or 9,000, maybe 10,000 German aliens, and a very small number of Italian aliens. Those arrests were done right away, and they were done pursuant to a statute that had existed since the country was founded. they weren't exactly justified. I mean, all it took to get you arrested if you were a Japanese alien along the West Coast is if you were a teacher in a Japanese language after-school program, if you were the minister in a local Buddhist church, if you were an officer of the Japanese Business Association of, whatever, whichever town you want, of San Francisco or Los Angeles or wherever, that was enough to make the government specify you as somebody of risk. The reason I think this is important right now is that all of those people, that first crop of people arrested, were all given hearings, individual hearings, and before boards of civilians, and the majority of them were not interned. They were deemed not to pose a security risk warranting their internment, and they were either released outright or they were released on a kind of parole. That's not what's happening right now. There have been no hearings of any kind as to the individuals who've been arrested. What happened in February was different from what happened in December and January. What happened in February was the wholesale arrest of an entire people on the basis of their ancestry, not under the Alien Enemies Act, but under this power that was pretty much made up on the spot called Executive Order 9066. And what was the main thing that was different about that, as I said before, is that unlike those earlier arrests, which, while sloppy, were at least targeted at individuals, the only criterion that got you arrested under 9066 was that you were of Japanese ancestry, whether you were a citizen or not. Interestingly, there was a big battle that was played out in January and February of 1942 between the military on the one side and the United States Department of Justice under Attorney General Francis Biddle on the other side. The Justice Department's position was, we already rounded up the dangerous people. We don't need to, the government does not need to uproot all of these people. We've taken care of the problem. Even that noted, celebrated civil libertarian J. Edgar Hoover was very clear that there was absolutely no need to do what the military was cooking up. But the military got the upper hand with President Roosevelt, and so he signed the order. And then the Justice Department had a sort of a bit of a dilemma on their hands. They were then going to have to defend in court a program that they had opposed. And so there are echoes, right? Echoes of these dilemmas of conscience that I think, it's easy to see some people encountering today, encountering 80 years ago.
So how did Japanese American communities respond to this forced relocation into these camps, leaving their homes and their businesses and so forth?
Very passively, I think, as a group, very passively. There were certainly resistors, and there was obviously great resentment. But I think Japanese Americans understood that with Pearl Harbor just a few months in the rearview mirror, there really was not any feasible way of resisting what was going on en masse. This was also a traumatized community in the sense that all of a sudden these folks, again, 2/3 of them citizens, were suffering the trauma of being identified with America's enemy. And it was a mark of great stigma and great shame on the community. That in some ways, if you talk to elderly folks in that community today, you can still feel some of that coming through. The main Japanese American organization, called the Japanese American Citizens League, ultimately counseled compliance with the Japanese American community that they represented, comply with the orders in order to show themselves to be good Americans. So in the main, Japanese Americans reported as they were instructed to do. They surrendered their cameras and their shortwave radios and their binoculars. They showed up on the appointed day at a local collection point, got on buses and trains, and were taken off to a set of temporary camps where they spent the summer of 1942. And then in the fall of 1942, they were moved out of the temporary camps into the 10 permanent camps that had been established. The most famous of which you may have heard of is the Manzanar camp, which is out in the Owens Valley in California.
So there was a government agency called the War Relocation Authority that operated these camps, that regulated these camps. Can you tell us a bit about how and why that agency was created and how it operated?
Yes, absolutely. The WRA, or War Relocation Authority, was created out of whole cloth in the middle of March of 1942. It was located in the executive office of the president, and it was created specifically to deal with the question of what would happen with this uprooted community once the military had finished their task of uprooting them and placing them into an initial confinement. So the WRA's job was to figure out how to manage this extraordinarily difficult logistical problem of having 125,000 people that they needed to accommodate in some way. It's important it's very easy to think that the government is just this monolith. It's one thing. I already mentioned to you that the government was actually of two minds about this whole program. There were military agencies that wanted one thing, and there were civilian agencies like the Justice Department that wanted something else. Same thing is true as to the WRA. The WRA was a bunch of New Dealers. It's a paradox. They were jailers, they were racial jailers, and they were New Dealers. The upper leadership of the WRA was populated by mostly people coming over from the Department of Agriculture, which was one of the core New Deal agencies. They were progressives of their time. Again, they don't look like it to us today, but in the context of their moment, they were progressives. Their vision was that Japanese Americans would be moved away from the coast and would be housed in sort of open communities, kind of like civilian conservation corps camps, where they would be permitted to come and go within the region and would be permitted and encouraged to use their skills in support of the war effort. Unfortunately, when the War Relocation Authority went to the governors of the states where Japanese Americans would be moved and said, here's our idea, I'll summarize it by saying that at this particular conference, the governor of Wyoming, Nels Smith, said, and I'm going to use a racial epithet here because it's what he used, if you bring these people into my state, there will be Japs hanging from every pine tree. So at that point, the WRA recognized that there was no way they were going to be able to do it in the modestly more humane way that they contemplated, and that in fact they were going to have to build prison camps. And that's what they did. And their job then was to run those camps and figure out how to manage a community of 125,000 people unjustly imprisoned on the basis of their race. Most of the senior leadership of the WRA thought that what they were doing was unnecessary. Many of them thought that it was wrong. Many of them saw that it was hurting the Japanese American community in needless ways. And yet they did their jobs.
What was the role of Milton Eisenhower in all of this, and what was his original vision, and how did that change?
Right, so Milton Eisenhower was Roosevelt's first choice to run the War Relocation Authority. He was the one that was tapped. This obviously is Dwight Eisenhower's brother. These civilian conservation corps camp ideas, those were his vision. He was someone who recognized that this was recognized the economic motivations of the people on the West Coast, recognized the hysteria, recognized the essential innocence of most of the community, certainly. So he came in, he lasted 100 days. He was there at that conference in Salt Lake City in April when the governor slammed the door in his face and said, not going to happen. You're going to have to bring them in and hold them under lock and key, and then frog march them back out of our states when this crisis is over. And he ended up quitting the agency after just 100 days because he was having trouble sleeping at night. This is very clear. This is clear from testimonies of people who were his friends at that time, and even from his own memoir. He was not able to, he did not want to be involved in what he was going to be expected to carry out. So he was kind of shunted over to a different agency. And they brought in a guy from the Department of Agriculture named Dylan Meyer, who became the director of the WRA and served the entire time that the WRA was in operation until early 1946, and did not have trouble sleeping at night.
Well, so I'd like to talk about your book, and I'm sure you join me in that enthusiasm.
Okay.
Lawyer, you can hold it up. Lawyer, jailer, ally, foe, which talks about the lives of the lawyers who were stationed at these camps. And they were employed by the War Relocation Authority, but they filled the role of government lawyer, city attorney, private attorney, and all of those roles at once. And how did they navigate what would appear to be, at least to the untrained skeptic, a conflict of interest?
Yeah. This book is a very close-up study of several white lawyers. Unlike my earlier work, which mostly focused on the experience of Japanese American prisoners, this book focuses in on this group of white lawyers who were employed by the War Relocation Authority and were actually stationed in the camps themselves. They were behind the barbed wire in the administration building. And they had this conflicted role of both being the legal advisor to the camp's administrators, but also expected to provide various kinds of support for the imprisoned community itself, even to the point of running sort of a legal aid office where Japanese Americans could come for help with legal problems. And you might initially think, well, what kind of legal problems are you going to have when you're locked up, in the middle of the Utah desert? Lots of them, because these were families that had been uprooted. So everything that people need, all of the legal services that people need in their regular lives, they brought with them into the camps. They needed to draft wills. People died and their estates needed to be administered. People needed, and in particular, people needed some assistance trying to hang on to the property that they had been forced to leave behind on the West Coast. So in a given day, these lawyers would go from a meeting with the camp director that was sort of trying to figure out the best ways to stave off a strike by the prisoners, or the best ways to ensure social control of this community. That was sometimes having to interrogate this community about their loyalty. And then, in the afternoon, they would have an appointment with a Japanese American young person who came to them because their mother had gotten injured they had fallen into a pit that government workers had dug and never marked, and a woman falls into the pit, breaks her hip, and the son comes to the project attorney, as they were called, the lawyers, and says, "What are my rights?" And so there, you picture that, right? I mean, it's the WRA that writes your paycheck, right? You are a lawyer for this agency, but you are also expected to, as best you can, try to provide some legal support for the prisoners. It's an absurd conflict of interest, and one that we know from the voluminous correspondence that they left behind, which is how I was able to write this book, we know that they were very aware of these conflicts. And the thing that I think is most interesting about the book is that it takes three men in particular who were in exactly the same job in three different camps during the first year of their existence, who were facing exactly the same kinds of legal problems and who were resolving them in different ways. Because their boss was 2,000 miles away in Washington, D.C. There were no cell phones where your boss could check in on you. So the only way they really communicated with the home office was by writing letters back to them, explaining what they were doing and the legal problems and social problems that they were encountering. Thank God they wrote them, because that's what I was able to use for my book. Speaking very personally, thank God they wrote them. So most of the time they were kind of on their own. And they were left in this exquisitely conflicted position, very much aware that the larger program that they were involved in was at a minimum unnecessary and harmful to this community. And they had to solve problem after problem after problem. So at one camp, the camp in Wyoming, the military says, you know what, we want to build a barbed wire fence right around the barrack areas where the prisoners all live. There were already barbed wire fences around the perimeters of the camp, large perimeters. The military wanted to rub their faces in it. We want to put a barbed wire fence right around within yards of the barracks. And we want to put searchlights there. Well, at Hart Mountain, the lawyer, this problem came across his desk, and his response was to kind of look at the regulations, look at the memorandum of understanding that the War Relocation Authority had with the Army, and kind of shrug his shoulders and tell the bosses in Washington, I don't see anything that would prevent this, so I guess we should let them do it. Right at the same time, exactly the same scenario was playing out at a camp in Arizona called the Post and Relocation Center, where the attorney was a guy named Ted Haas, very different background from the lawyer in Wyoming. His reaction was to go to his typewriter in his barrack room and pound out a petition opposing the fence that he then circulated to other WRA employees, trying to prevent this fence that he knew was going to be nothing but an insult to the imprisoned community. So it's these kinds of contrasts that I think are so fascinating, because it's almost like a little petri dish. It's almost like a controlled study. You got the same job description, same problems, same kind of camp, and yet these men approach their jobs in very, very different ways.
And so you also wrote in your book about how the lawyers at the camps in some cases were actually complicit in making life in the camps even harder. And you mentioned the example of Wyoming. So there's this attorney, Jerry Housel, in the Hart Mountain camp in Wyoming, who wrote a letter to the WRA in which he suggested banning traditional Japanese activities like judo and dance and penmanship,
Right.
on the theory that this would somehow stoke a relationship with the Japanese Imperial Army.
Right.
What does that say about broader American views of Japanese people? And how did the people who were interned at the Hart Mountain camp react to that?
Well, the people, I'll just answer that last bit first. The people at the Hart Mountain camp didn't know that this lawyer was suggesting that. And in fact, the WRA bosses in Washington did not follow Jerry Housel's suggestion. But I think that Jerry Housel's response, now mind you, this is a guy who, when he got to the camp, one of the first things he started to do was to take Japanese lessons, because he wanted to get to know this community. He was going to have some responsibilities to work with them. And so his initial position was, rather supportive of the practice of Japanese cultural activities in the camps. Saw them, understood them as being, I mean, it's not so much that he was sort of a Japanophile as it was that he understood that if this community was going to be compliant, if they were going to be peaceful, if they were going to follow the rules, it would help if they felt some degree of freedom to engage in kinds of activities that they were accustomed to and interested. So he was initially a supporter, but he was also the son-in-law of the mayor of an adjacent town, Powell, Wyoming, which was virulently opposed to the presence of Japanese Americans, most of them, in town. And his father-in-law was something of a ringleader against the presence of Japanese Americans in the camp. So at the end of his tenure, as Jerry Housel is leaving to join the Navy, he writes this letter, this blast to the Home Office saying, we got to stop this. People look in through the barbed wire, local people look in through the barbed wire fences, reporters come, and they see people practicing judo, doing Japanese flower arranging. Terribly dangerous activity. And this blackens the reputation of the WRA. It makes us look like we're coddling these folks. So we need to abolish this. We need to stop this in order to preserve our own reputation and protect our own institutional interests as a government agency.
What do you think motivated someone like Jerry Housel to take a job like this?
He was a Wyoming boy. He had grown up in Wyoming and went to the University of Wyoming's law school. He was a very rare bird. He was a Wyoming Democrat. There weren't many of those then, and there aren't many of those today. He graduated from law school right as FDR came into office. He was a New Deal guy. He wanted to come to Washington. He worked for several agencies. And then when the war started, he knew that he wanted to go home. He knew that he was going to make his life and his career in Wyoming. And he was married to a Wyomingite who was the daughter of the mayor of Powell. So for Jerry Housel, this was an opportunity to make a career move, really, ultimately. It was a way to continue to work for the government, to continue to serve his country during wartime, but to do it as a kind of transition, I think, to what he hoped would be his life afterwards as an attorney in Wyoming. And he became one of the most successful Wyoming lawyers of his generation in the years after the war. So I think his motivation was not any particular antipathy towards Japanese Americans. I think it was largely, a combination of sort of ambition and opportunity.
So you noted that prisoners at the camps were required to fill out questionnaires regarding their loyalty.
Yes.
And can you tell us what was in those questionnaires and what happened if someone was deemed to be disloyal to the United States, or just refused to fill it out?
This is one of the central sort of ironies or paradoxes of this whole period. In the spring of 1942, every Japanese American is put behind barbed wire because they're all presumptively disloyal. 6 months later, the WRA, which is trying to run these camps and recognizes that they have a bear of a problem on their hands, there are riots and strikes and things that are starting to foment. They want the camps to start to release people, to diminish the size of the population. Simultaneously, the U.S. Army decided that they wanted to open military service for the Japanese American young men in the camps. So the military and the WRA's interests kind of coalesced. They both wanted to be able to start getting people out of the camps. But they knew that they couldn't do that unless they could certify to the American public that the people that they were releasing were safe, were loyal. So they develop a 4-page, I have a hard time not laughing when I tell this part of the story. They develop a 4-page questionnaire, about 30 questions, that they make everybody over the age of 18, maybe 16, fill out. And it's kind of like a questionnaire that you might fill out for jury service, maybe. I mean, it's, where do you live? What magazines do you read? Do you speak? How good is your English? How good is your Japanese? What social and cultural activities do you participate in? Do you have investments in Japan? And then there were two questions in particular at the end that were sort of this whole process is undoing, because they asked Japanese Americans, question number 27 said, are you willing to serve in the U.S. Armed Forces wherever ordered? And question 28 said, are you willing to forswear allegiance to the Emperor of Japan and swear allegiance to the United States? Now, if you just try to imagine yourself into the position of an 18 or a 19-year-old young guy, locked up with his family on the basis of race, you're now being asked to leave your aging parents behind in a prison camp and take up arms on behalf of the country that has locked you up? Not so crazy about that idea, many of them. Question 28, asking them to forswear allegiance to the Emperor of Japan, literally encapsulated the racism that had gotten them behind barbed wire in the first place, because they had never sworn allegiance to the Emperor of Japan in the first place. They were U.S. citizens. So these questions were infuriating. It led to more unrest. And just to wrap up the answer to this, then the government had a huge problem on their hands, because now you've got tens of thousands of 4-page handwritten forms that you have to turn into pronouncements about who is loyal and who is disloyal. So the government then set up a whole bureaucracy for processing these forms that basically took the answers to the questions and tried to turn them into like points on a scale. So if you had done Little League Baseball, you got a +1. If you had done judo, you got a -1. If you were Christian, you got a +2. If you were a Buddhist, you got a -2. So it was this kind of thing, just based on this absurd caricature, and also based on the idea that Japanese spies would be the ones doing judo. I mean, I've never had spy training, but I'm thinking that if I'm a Japanese spy in the United States, the last thing I'm going to do is run out and start doing judo. Maybe I'll play baseball instead. So that's what happened. And then a relatively small subset of these people were deemed disloyal, and the government put them on trains from the 9 of the 10 camps and moved them all to one of the 10 camps, which went from being called a relocation center to being called a segregation center. And that was the Tule Lake camp in Northern California. And those, there's a whole story about them. But that basically, there was a sifting that was done in which a subset of the community was deemed disloyal and moved to a kind of a harsher confinement in one of the camps.
And just parenthetically, am I right, is my recollection right, that there was actually a Japanese-American unit that fought in Italy with distinction,
yes,
while their parents were interned?
The 442nd Regimental Combat Team and the 100th Battalion, which was mostly made up of folks from Hawaii. Yes, you are remembering correctly. So those are young men who either volunteered into the service from the camps, or the larger percentage were people who complied with the draft and were drafted into the camps. I just want to drop the footnote that the story that got me interested in this 25 years ago was the story a story that happened at the Heart Mountain Camp in Wyoming, where a group of about 80 young men decided that they'd had enough. When they got their draft notices, they said, sorry, we're not doing this. They didn't show up for their physicals. They were prosecuted for felony draft evasion, convicted in federal courts across the West, and then sent to federal penitentiaries for terms of between 1 and 3 years. They believed themselves to be practicing a different kind of patriotism from the patriotism of the young men who served, namely the patriotism of protest.
So I want to turn the conversation now to a person you mentioned earlier, and that's Fred Korematsu, whose name we know from the famous Supreme Court decision. He was supposed to have been interned with his family, but he refused. And he said, and I quote, "To be threatened with punishment because you look like the enemy is wrong. I don't even have ties with Japan, nor have I ever been there." So his case went all the way to the Supreme Court, and can you describe what their decision was?
Yeah, so one of the most, I was going to say famous, but I think I'll say infamous cases in the history of the U.S. Supreme Court, up there alongside Dred Scott versus Sanford and Plessy versus Ferguson, for those of you who are familiar with some of these horrible old unjust decisions. By a 6-3 vote, the United States Supreme Court decided that the government had the power to to remove Japanese Americans from their homes and to bring them eastward on the basis of national security, on the basis of the military threat, and the majority denied that race was the explanation for what the government had done. That was the position of 6 of the justices. They upheld Fred Korematsu's conviction for defying the military 9066. 3 of the justices went the other way and dissented. Frank Murphy said that the court had tumbled into the abyss of racism, right there in the U.S. reports. Robert Jackson, a name that you'll see if you look around this museum because he became the lead prosecutor at the Nuremberg trials a couple of years later. Robert Jackson dissented and said, what we're doing today, approving of the racial relocation of citizens, in an official opinion of the United States Supreme Court, saying that the Constitution is not offended by that, we are setting down a loaded weapon that can be used in the future by the hand of anyone who has a claim of urgent need in a time of crisis. And I think that that's something that perhaps we might well reflect on in the moment that we're in right now. The Supreme Court in 2018, I'll say, purported to overrule Korematsu versus United States. They said they did. I could get all lawyerly on you here and explain why I think there's actually some question about whether that's actually what they did effectively. But they certainly said that Korematsu was wrongly decided and had been condemned in the court of history. So at least that decision seems now to be radioactive and not something that a future government could hold up as a valid precedent for comparable action.
So Fred Korematsu, his act was a kind of a radical act in the sense of being radically disobedient. But he thought the law was unjust, and he thought that the law was contrary to the ideals of the United States Constitution. Did that represent a personal respect, do you think, for the rule of law? And how would we square that personal disobedience with the fact that the United States Supreme Court had decided that the law was constitutional?
You're asking an interesting question about what motivates people to resist. It so happens that just last week, Fred Korematsu passed away in the year 2004. I had the deep privilege of getting to know him at the end of his life. But his daughter, Karen Korematsu, has devoted her life to perpetuating and extending her father's legacy, and she actually came and visited my law school, UNC Chapel Hill, just last week, and spoke to our students. And she related that when she would ask her father why he had done what he did, she said that he simply said what the government was doing was wrong, and I was right. I had studied civics in high school. I had studied the Constitution. I just had a deep sense inside that they were wrong and I was right. And that was it. So there wasn't, according to Karen, there wasn't, kind of a deep, kind of lawyerly search through legal principle and constitutional law. It was an impetus that he had from within, just a kind of innate sense of right and wrong that propelled him through that. And by the way, I will say, very much like the young men who I mentioned who resisted the draft, Fred Korematsu was avoided and largely condemned by the Japanese American community at the time. Because, like the draft resistors, Fred Korematsu was saying no and was standing toe-to-toe with the government and saying you're wrong at a time when the Japanese American community was as beleaguered as a community can be and incarcerated because of the suspicion that they were all disloyal. So you would think that they would embrace somebody like Fred Korematsu fighting for them. Very much the opposite was true. He was very unpopular and really was kind of exiled almost from the Japanese American community for years, for decades, frankly, certainly through until the 1980s.
All right, well, we've got a little bit of time left before we open it up to questions, but let me ask you, if we dare, bring it to today. Do you think that the United States has put sufficient safeguards in place to prevent wartime incarceration without due process of law from happening again?
It's been nice this evening. Thank you so much. So my answer to that, it won't surprise you, is yes and no. Yes, in the sense that if you look at our statutes, if you look at our constitutional decisions of the Supreme Court, you will find a very different legal landscape from the one that the court had in 1944. 44 was 10 years before Brown versus Board of Education. It was a different world, legally, constitutionally, from the one that we live in. So, in the main, I would say that there are guardrails. But the problem is that guardrails don't enforce themselves. Guardrails are enforced by human beings. And if human beings are not interested in following them, if they're not interested in honoring the basic structures of our American government, not interested in respecting the boundaries between the three branches of the government, executive, legislative, and judicial, then we have a bunch of stuff on paper. I tell my students, you may do the same, Dale. I tell my students, first-year students in constitutional law, every year, the first day, that they should not be deceived into thinking that what they're going to be studying is some kind of foreordained thing that was on the kind of the back of the tablets that Moses brought down from Mount Sinai. That this whole structure only works because we agree to let it work. If we don't agree to follow it, it's just a document. And that's my worry right now.
Well, so we have some questions from the audience that I think are really interesting. One of them starts with the question of the commission. There was a commission that was established in the 1980s to study the circumstances surrounding the Executive Order 9066 And so the question is, how did the Commission on Wartime Relocation and Internment of Civilians investigate the incarceration, and what were the findings?
One of the last things Jimmy Carter did before he left office was to sign the legislation that created this commission. The commission itself was the work of a group of senators and congressmen, including the very small number of Japanese American senators and congressmen. Some of you may remember the name of Senator Daniel Inouye from Hawaii. Any of you, any Watergate fans in the audience will remember Senator Inouye from those hearings. A fellow named Norman Mineta, mayor of San Jose, who went to Congress and then was tapped by Bill Clinton to be Secretary of Commerce, I believe, and then held over by George W. Bush into his administration to be Secretary of Transportation. So there was advocacy that produced this commission. The commission hired researchers. The commission went around the country taking testimony from government officials of that day, but also this was really kind of, in a sense, the coming out moment for the Japanese American community. This was the first opportunity that they had to speak to the government and describe their pain and the trauma that they had endured. Simultaneously, there were people crawling through the bowels of the National Archives and turning up all kinds of evidence that had gone undisclosed for decades. As a result of that process, eventually Congress passed a piece of legislation called the Civil Liberties Act of 1988, and that act pronounced that what was done to Japanese Americans was not on the basis of military necessity, but was instead a product of wartime hysteria, racism, and a failure of political leadership, and recommended that the president issue each surviving former prisoner an apology and a check for $20,000. President Reagan surprised some people by signing that legislation, that apology went out and those checks went out. Needless to say, $20,1990 were a pittance compared to the losses that you had endured back in 1942. But many, many, many of these folks that I've interviewed have told me that what mattered to them was not the money, it was the apology. I've gone into lots of homes of Japanese Americans that have the letter from the president framed on the wall. Very, very touching.
Another audience member asks, if Eisenhower had stayed on the project, do you think he could have convinced the other WRA regulators not to treat Japanese Americans like spies and criminals? And do you think there were any steps that could have been taken that would have made the experience at the camps different or better? Would it have mattered?
I think it would have mattered a little. I mean, I think that the camps would have been run in a more benign, more humane way under Milton Eisenhower's leadership than under Dylan Myers. But we have to recognize that even under Dylan Myers' leadership, remember, the WRA was a group of the progressives of their era, and they Japanese Americans suffered brutally and devastatingly in these camps. I don't mean at all to diminish anything about the suffering of the community. But the WRA, I think the interesting question is, the WRA was attacked from the first moment it came into existence until it closed up shop. Attacked by Americans, by journalists, and by the military leaders who said they were a bunch of soft-headed, squishy, social engineering liberals that were going easy on Japanese Americans. And so the WRA was constantly kind of having to look over its shoulder and defend itself. There were congressional investigations of the WRA and how it was running the camps. So I think the interesting question is not so much how would the camps have run if Milton Eisenhower had been there instead of Dylan Meyer. I think the interesting question is, how would the camps have run if these forces opposing the WRA had been successful and the camps had been turned over to military control. I think we would have seen very different camps from the ones the WRA ran. Again, this is not to say that the WRA camps that this was a humane venture. It is simply to say that there were realistic, horrible alternatives that did not come to pass.
Another audience member asks, were Japanese Americans interned at the camps allowed to run businesses, or was there forced labor on the other side? Or was there forced labor? Did the government pay them? Did they have to support the war effort? What?
Yeah. So these were little cities, folks. During the first year and a half of its existence, the Heart Mountain camp in Wyoming was Wyoming's third largest city, with a population of about 11,000 Japanese Americans. That put it third to Casper and Cheyenne. So this was a small city, and it ran mostly on the labors of on the labors and the contributions and the resilience of the Japanese American community. The WRA, within limits, supported the Japanese American community in trying to create vestiges of normal life, if you want to call it that. That was part of the job of the lawyers, right? So yes, there was a system of stores in the camps that were run by a Japanese-controlled co-op who incorporated the co-op. It was the white lawyer that helped this community set up these. They would take a barrack and put black curtains over the windows and turn it into a little movie theater. There were shoe repair shops. There were hair salons. Like all of these things, Japanese Americans found the strength of character to try to create and build for themselves, with some support from the WRA, some semblance of a community. There was a community government. There was a judicial commission that adjudicated petty offenses. It was in some ways like a little American small town, like in certain ways. On the other hand,
except that it was surrounded by
searchlights and barbed wire, right?
Just like a little Plano.
Just like a little Plano, exactly. Well, I've not been to Plano. I'll take your word for it. But yes, was there out-and-out slave labor? No, there was not out-and-out slave labor. But Japanese Americans were strongly encouraged to engage in agriculture, to go out and work on local farms to help bring in the crops. They were paid. There was a 3-level pay scale in the camps. Unskilled workers were paid $12 a month. Semi-skilled workers were paid $14 a month. And skilled workers were paid $19 a month. What this meant in practice was Jerry Housel, the lawyer who ran the project attorney's office, was making a salary of about $3,500 a year. And the Japanese American incarcerated lawyers who had been removed from the West Coast and volunteered to work in the project attorney's office alongside Jerry Housel were making $19 a month.
So the questions are mounting, proliferating as we get deeper into this. So I'll have to pick pretty carefully. But one question I was curious about: do we know if Japan had any knowledge of these camps?
Oh, definitely. Yes, I mean, Japan, remember that if 2/3 of the residents or prisoners were citizens, that means that the other third, the older segment, were citizens of Japan. And the Japanese government had a strong interest in the well-being of the Japanese, particularly the Japanese aliens, the citizens of Japan in the camps. There were no diplomatic relations, obviously, between the United States and Japan during the war, but the Spanish government was designated the kind of intermediary between the United States and Japan. And in fact, Japanese diplomats would come to the camps and would investigate the conditions in which they were being held. The Japanese also, the Japanese in Japan also used the fact of this incarceration as a kind of propaganda tool, right? I mean, they say they're all about freedom and liberty and civil rights. Look what they're doing. They've got people in concentration camps, which was a term that was used at that time for these places. An historically authentic term that has obviously come to have a different connotation to us today. So yes, Japan did keep tabs. And there were even some people who demanded to be expatriated from the United States, and there were some ships that sailed from the United States to Japan with people who had decided to give up on America and go have their futures back in Japan.
There's a saying, one of our audience members points out, there's a saying that goes, history may not repeat itself, but it often rhymes. Is there an apparatus in the law that defends against executive orders of this kind?
Of course. I mean, of course.
Can you say a little more about that? Because there might be some interest in that.
There's this branch of the government called the judiciary, and their responsibility is to, apply and interpret the laws, to determine when the government has transgressed the outer boundaries of its authority, when the executive is operating in defiance of the law rather than consistently with congressional statutes. So yes, I mean, there certainly are mechanisms, but as I said earlier, the difficult question right now is, and it looks like if we haven't crossed the line, we are at the line of an administration that is unwilling to follow court orders. We don't know yet exactly how that's going to play out or what the scope of it will be, if in fact it develops in that direction. But obviously, if the executive is not willing to follow court orders, the courts are kind of stuck. Like the way that court orders get enforced is through the U.S. Marshal Service, which is part of the Justice Department. Right? So it's the executive that ultimately is responsible for carrying out judicial orders, and if they won't do that, then the courts have no way. They have no way of enforcing their own judgments.
So on that somewhat
cheerful,
uncertain, ominous note, what are you working on now? What's your next book? Maybe it's going to be about this period. I don't know, but what's your next?
Yeah, so there's two things I'm working on, a smaller project and a big project. The small project is about a mostly forgotten compensation system, reparations system that the U.S. government set up for Japanese Americans in the late 1940s that allowed them to put in claims for the property that they had lost as a consequence of being removed from their homes. It was like a little incipient mini reparations system. Very little is known about it. Very little has been written about it. It didn't do a very good job, surprise, surprise, but it still is noteworthy that within a few years of the end of the war, the government, while not admitting wrongdoing, at least recognized that there had been hardship that had been imposed on Japanese Americans that warranted some form of compensation. So I'm going to write about that. But my big project is nobody has ever written a history of the War Relocation Authority, remarkably. Well, no, I take that back. There is one history of the War Relocation Authority written by the WRA. They actually come off pretty well in that one. So I would love to be able to bring that project to life. But it's a multi-year project of archival research and a lot of hard work.
So I think I said that was the last question, but actually I have one more question. Maybe you can answer it in 30 seconds or a minute.
Impossible.
Impossible, because we're lawyers and law professors. What lessons should the American public take away from this episode?
The urge to scapegoat is eternal. It's timeless. It happens everywhere there are humans that are in crisis. It's the reason that this museum is here. It's what drove my own family out of Nazi Germany at the very end of 1938, after my grandfather was incarcerated at Buchenwald. That's timeless. And so vigilance, I think. Vigilance. Trying to preserve our energy in the midst of an overwhelming period of change, to be vigilant and to pay attention and to look for the warning signs of the identification and persecution of an internal group as somehow not American and an enemy.
Thank you so much, Eric, for the gift of this.
Thank you, Dale. I appreciate it.
And thank you to the audience.
Thank you very much. Thank you very much.
I'd like to thank both Eric Muller and Dale Carpenter for a really fascinating, I don't get a chance to roll this out, a scintillating discussion that was wonderful. I would like to ask all of you to hold on just for 1 minute so that Eric can go out to the lobby first, because he's going to be signing books. And I would like him to get there before you all get there. Go. And for those of you who are interested in having a book signed who do not have a copy of the book, there's a few, like a handful left in the bookstore. Otherwise, thank you all so much for joining us this evening. And I wish you safe travels.
Thank you. Thanks so much, Dale. This was a pleasure.